Hello and welcome to The Print. This is Khadija Khan from New Delhi, and today I will be telling you about a controversial new provision of the Bharatiya Nyaya Sanhita under section 152, which criminalises acts or attempts to incite secession, armed rebellion or separatist movements that threaten the country's stability. In a recent order passed this month, the Rajasthan High Court has flagged concerns about the re-entry of section 124A into the BNS, which dealt with the offence of sedition under the IPC. The court also said that it appears that section 123 has been reintroduced by another name. Section 152 of the Bharatiya Nyaya Sanhita, which seeks to replace the Indian Penal Code, criminalises acts endangering India's sovereignty, unity and integrity. But the Rajasthan High Court in this order said that this should be used as a shield for national security and not as a sword against legitimate dissent. Notably, the court said that the ingredient of intention or mens rea is mandatory for committing the offence under section 152. By way of a 32-page ruling, Justice Arun Monga said that section 152 of the BNS has to be read, meant and interpreted in a way that it mandatorily requires the act to be committed purposely or knowingly. In doing so, the court flagged the reintroduction of a modified section 124A to the statute books, which relates to the offence of sedition, while saying that the provision appeared to be reintroducing section 124A or sedition by another name. Notably, this judgment assumes significance in light of Union Home Minister Amit Shah's announcement in August of 2023, where he had said that the offence of sedition will be completely repealed in the BNS, which was soon to be proposed in Parliament at the time. Another thing to keep in mind is that a challenge to the offence under section 124A has been pending before a 5-judge bench of the Supreme Court since September 12th last year. The first plea challenging the provision, however, dates back to the year 2021 and was filed by 2 journalists. In 2022, a CJI N.V. Ramana-led bench of the Supreme Court had put on hold all pending proceedings in sedition cases until the central government completes its re-examination of the provision. But first, let us understand the offence of sedition under the new BNS. Section 152 stipulates life imprisonment up to 7 years along with a fine for persons who attempt to initiate secession, armed rebellion or separatist activities that endanger India's unity and integrity. Notably, this provision is analogous or similar to the offence of sedition given under section 124A of the erstwhile Indian Penal Code. It also retains the explanation to that provision, which acts as a safeguard and specifies that comments expressing disapproval of measures or other government actions seeking to alter them by lawful means without exciting or attempting to excite secession, rebellion, etc. won't amount to sedition. While the previous provision under the IPC had fixed a punishment of up to 3 years for the offence, the updated provision under the BNS increases this punishment to 7 years. On the other hand, section 197 of the BNS punishes imputations and assertions prejudicial to the national integration of the country with up to 3 years of imprisonment or a fine or both. The provision also disallows making or publishing any accusations, petitions, appeals, false and misleading statements to the extent that a class of people cannot bear faith and allegiance to the Constitution of India or uphold the country's sovereignty and integrity simply because they belong to a particular religious, racial, language or caste group or community. It also prevents persons of any religious, regional, racial or other groups from being denied or being deprived of their rights as Indian citizens. No assertion can be made that causes disharmony or feelings of enmity, hatred or ill will between people, it also says. What was the case? In this case, a complaint was filed by an Indian citizen called Lakhvinder Singh against Sikh preacher Tejender Pal Singh. In July this year, saying that he posed a threat to India's integrity and sovereignty while accusing him of offences under sections 152 and 197 clause 1c of the Bharatiya Nyaya Sanhita. The complaint was born out of an audio-video recording on Singh's Facebook account, where he reportedly expressed sympathy for Amritpal Singh, an elected Lok Sabha member from Khadur Sahib constituency who is currently lodged in an Assam jail. According to the complaint, Singh's speech was anti-national. It advocated for Khalistan and was deeply offensive to Lakhwinder's religious sentiments. Lakhwinder claimed that this could incite public unrest and the preacher was associated with pro-Khalistani people. This is exactly what led to the FIR against him. In its December 16th ruling, the Rajasthan High Court traced the origins of this offence as that of a colonial-era invention which was introduced in 1870 for punishing acts of hatred, contempt or disaffection towards Her Majesty or the Crown. Pointing out that the offence of sedition under section 124A of the IPC was done away with in the BNS, the court said that a new, somewhat similarly worded provision was brought in by lawmakers in the parliament that criminalises acts or attempts to incite secession, armed rebellion and other such activities. The court pointed out that since the explanation to section 152 specifically exempts awful criticism of government policies aimed at reform or alteration through lawful means, the preacher's actions will not fall under this provision's ambit. Saying that this explanation serves as a safeguard, the court said it also protects expressions disapproving of government policies as long as their criticism doesn't incite rebellion or separatism. This distinction has been carved out for preserving lawful dissent and democratic freedoms, particularly the freedom of speech and expression, the court noted. Underlining that there must be a direct and imminent connection between the speech and the likelihood of rebellion or secession to invoke such a provision, the court ruled that legitimate dissent or criticism cannot be equated with sedition or anti-national acts. Finally, the court quashed the FIR filed against preacher Tejender Pal Singh while adding that the continuance of the complaint and the resultant proceedings against him amounted to an abuse of the process. That's all for today. For more legal updates, keep watching The Print.